Welcome to the Standards Framework and Standards Strategy online presentation. This presentation will cover the following four topic areas. Number one, what is a standard? Number two, the legal framework surrounding the provision and use of standards. Number three, how law surrounding standards is changing. And number four, an overview of the 7 standard strategy modules. Let's start by defining what a standard is. A standard can be defined as an agreed way of doing something. In the rail industry, the aim of standards is to provide for the most cost-effective, efficient and compatible means of rail system delivery whilst providing for a safe railway. To meet this aim, standards define and record what has to be done, or how something needs to be done. This avoids having to reinvent the wheel each time the same situation occurs. But standards are not just for ensuring compliance. They also help industry to innovate as they remove barriers to progress. They make the market a level playing field for all players across Europe and beyond. They help identify areas for improvement, and they help GB Rail maintain its prestigious position as one of the safest railways in Europe. RSSB makes standards even more powerful by bringing together industry experts to draft them collaboratively and efficiently, reducing costs to industry. There are many types of standards currently in use in the rail industry. These include EU-wide legislation, UK legislation, railway group standards, which contain national rules, rail industry standards, approved codes of practice drafted by the regulator, national operations publications, which include the rulebook and working manuals, British, European and international standards, rail industry approved codes of practice, managed by RSSB, codes of practice, company standards, project standards, and guidance produced by the regulator, industry bodies and associations. These standards cover the whole railway system. Some examples include a railway group standard covering visual indicators at level crossings, a British standard detailing the speed of escalators, an EC regulation on the height of platforms at stations, UK legislation covering working at height, a company or project standard covering drugs and alcohol screening and for-cause testing, a rail industry standard on the maximum noise levels for transportable plant, and guidance on how to assess electromagnetic fields. The legal framework surrounds the provision and use of standards. In this section, we will cover the Railway Regulatory Framework UK, the Railway Regulatory Framework EU-wide, the scope and force of standards, the legal requirement to draft standards, and the legal requirement to comply with standards. The legal framework surrounds standards in the UK. In the UK, the highest level of statute law is an Act of Parliament. An Act is usually classified as part of criminal law. Breaking it can therefore result in prosecution, punishable by a large fine and/or imprisonment. Acts can take a long time to travel from being a bill to becoming law. They go through multiple readings in the House of Commons, and if they achieve that, they then go on to the House of Lords for more readings. If they achieve that, they then gain royal assent from the Queen and they become law. Acts contain only general requirements, but many of them, referred to as enabling acts or umbrella acts, allow ministers to make regulations, orders and rules for specific circumstances under them. Regulations made under these acts require a fraction of the parliamentary time to gain approval, approximately 50 days, and have much more detailed requirements in them than the actual enabling act will. An example of the difference between the contents of an act and regulation can be found in Section 2 of the Health and Safety at Work, etc. Act 1974, which states, "It shall be the duty of every employer to ensure, so far as is reasonably practicable, the health, safety and welfare at work of all his employees." This is just a standard to meet, and the Act doesn't provide any additional information on how to achieve it. More detail can be found in the Management of Health and Safety at Work Regulations 1999, where in Regulation 3 it states, Every employer shall make a suitable and sufficient assessment of the risks to the health and safety of his employees to which they are exposed whilst they are at work. The Health and Safety at Work, etc. Act is a non-industry specific piece of legislation. It applies to all industries, not just railways, and the same can be said of many of the regulations made under it. But there are also some industry specific regulations made under the Act as well. An example being the Railways and Other Guided Transport Systems Safety Regulations 2006. Many of the regulations made under the Act, although not all, are supported by additional information drafted by the regulator. This information is available as either an approved code of practice, also known as an ACOP, and/or guidance notes. Usefully, the ACOPs and guidance notes are often published together with the regulation they support in one document. Approved codes of practice give practical guidance on how to comply with regulations they are linked to. ACOPs have a special legal status. They are often referred to as quasi-legal. This means if an employer is prosecuted for a breach of health and safety law and it is proved that they have not followed the relevant provisions of the approved code of practice, a court can find them at fault, unless they can show that they comply with the law in some other way. Guidance is slightly different though. It interprets the law and is designed to help people to understand what it means. Guidance has no legal status. Following it is not compulsory and employers are free to take other action. But if they do follow guidance, they will normally be doing enough to comply with the regulations the guidance is linked to. The legal frameworks around standards, EU-wide. In 2016, the UK held a referendum and decided to leave the EU. The nature of this process is likely to take some time, and so for the foreseeable future, we will assume that GB Rail will still need to comply with EU law described in the following slides. In 1973, the UK joined the European Common Market, now known as the European Union. This introduced a new tier of legislation. The drive behind this new legislation wasn't to improve safety, it was to break down barriers to trade. The four main aims of EU railway legislation are 1. Market opening for rail products and services. 2. To harmonise approval processes for authorisations and certifications. 3. To harmonise the technical and safety requirements. And number 4. To facilitate cross-border train operations. European legislation is published in two formats, European Directives and European Regulations. And very much like the drafting of UK legislation, the drafting of European legislation can be a lengthy process. In fact, it involves three players, the European Commission, the European Parliament and the European Council. The European Union issues directives which apply to all member states. These directives are high-level documents and are only directly binding on governments, not individuals or organisations. Each domestic government must ratify a directive within a certain time frame by transposing it into national law. In the UK, this can be done at Act or regulation level as deemed appropriate. Each domestic government has the freedom to transpose the directive in a slightly different way. Some even add additional requirements to meet their particular needs. An example of this process can be found in the Railway Safety Directive 2004/49/EC. The UK government took 2 years to transpose it into the Railways and Other Guided Transport Systems Safety Regulations 2006. Supporting the regulation is a guidance note drafted by the regulator. A second example can be found in the Railway Interoperability Directive 2008/57/EC, where the UK government transposed it as the Railway Interoperability Regulations 2011. Two more examples include the Health and Safety at Work Framework Directive, which is transposed into the Management of Health and Safety at Work Regulations 1999, and the Machinery Directive, which is transposed as the Supply of Machinery Safety Regulations 2008. The European Commission can also issue European regulations. Once published, European regulations become law in all member states simultaneously. The requirements contained in them are identical in all member states and require no transposing. Example European regulations include the Common Safety Methods, known as CSMs, and are linked to the Railway Safety Directive, and the Technical Specifications for Interoperability, known as TSIs, which are linked to the Railway Interoperability Directive. There are currently 11 published TSIs applicable to the GB mainline railway system. They include infrastructure, persons with reduced mobility, operations traffic management, energy, locomotives and passenger rolling stock, telematic application for freight, telematic application for passenger services, safety in tunnels, noise, rolling stock freight wagons, and control, command and signalling.
There are currently 6 CSMs applicable to the GB mainline railway system. 2 are applicable to transport operators. They are the CSM on risk evaluation and assessment and the CSM on monitoring. The other 4 are only applicable to the regulator, ORR. They are the CSM for assessing conformity with the requirements for obtaining a safety certificate, the CSM for assessing conformity with the requirements for obtaining a safety authorization, the CSM on supervision, and the CSM on assessment of achievement of safety targets. EC regulations are not binding on the individuals or organisations on their own. Each regulation is made binding in the UK by being linked to an existing piece of UK legislation. In the case of the Common Safety Method on risk evaluation and assessment, compliance is made by referencing it to Regulation 51A of the Railways and Other Guided Transport System Safety Regulations 2006, where it states that the requirements for a safety management system referred to in Regulation 31A are that it applies to relevant parts of CSMs. In the case of the Infrastructure Technical Specification for Interoperability TSI, compliance is made by referencing it to Regulation 17.1 of the Railways Interoperability Regulations 2011, where it states that subsystem is required to conform with all or part of the TSI, the procedures specified in the TSI or part of TSI with which that subsystem is required to conform. Compliance with the TSI can be achieved by meeting essential requirements contained within it. Essential requirements are listed under 6 headings. They are safety, reliability and availability, environmental protection, technical compatibility, health, and accessibility. This chart shows the scope and force of different standards. At the top of the chart, we have standards containing legal requirements applicable to RSSB members and stakeholders. These are found in EU-wide directives and UK legislation, including acts and regulations. On the next row down, we have standards containing requirements that are compulsory in certain circumstances. They include EC regulations and railway group standards that set out the national technical rules and national safety rules for the GB mainline railway. The next row lists the standards that contain requirements adopted by members and others through their safety management systems and contracts to meet their legal obligations. They include rail industry standards, national operations publications, British, European and international standards. The final row contains requirements that our members and others can derive from or interpret to meet their legal obligations. These include guidance produced by EU-wide organisations, the regulator, RSSB, industry associations and bodies. Other standards that can be plotted on this chart include company-wide standards, normally contained in the safety management system, and project standards that are limited by location and or time. It's worth noting that regardless of where a standard sits on this chart, they are all equally valuable and useful to RSSB members and others, as they help them to meet their legal obligations. We can transpose this chart into a pyramid to show the same standards but with different scales. We've changed the scale showing the scope of standards to one showing the level of detail contained in each one. At the top of the pyramid, we can see that high-level legislation doesn't contain a lot of detail, but is supported by other standards containing more detail, including rail industry standards, national operation publications, British, European, international standards, and some guidance. At the bottom of the pyramid, we have the company and project standards that contain the most detail. Now let's look at legal requirements behind drafting railway standards. Railway group standards currently set out the national technical rules and national safety rules for the GB mainline railway system, and RSSB, on behalf of industry, manages the process of drafting and publishing them. The Railway Safety Directive mandates on member states, e.g. governments, the requirements to produce national safety rules. National safety rules are only permissible where there are no European rules, e.g. TSIs or CSMs etc., covering that subject area. National safety rules include common rules for IMs and RUs for operating trains and infrastructure, safety methods such as rules for assessing route compatibility, and some requirements concerning staff undertaking safety critical tasks, and rules concerning investigations of accidents. The Railway Interoperability Directive mandates on Member States the requirement to produce national technical rules. National technical rules are only permissible where there is a TSI-specific case or open point on the GB mainline railway network. National technical rules include additional requirements for technical compatibility with the GB network that structural subsystems vehicles must meet before they receive authorisation for placing into service, limits that structural subsystems vehicles must be maintained at to remain in service, and how structural subsystems vehicles must be classified or described. But what does national status in national technical rules and national safety rules mean? Well, national rules are national because they're made mandatory by the national member state and are quoted in legislation. The term national refers to how they're given force, not their geographical scope. In the UK, the requirement to comply with national safety rules is defined in Schedule 1 of the Railways and Other Guided Transport Systems Safety Regulations 2006, which states that the basic elements of a safety management system are procedures to meet the relevant technical and operational standards or other requirements as set out in TSIs and national safety rules. In the UK, the requirement to comply with national technical rules is defined in the Railway Interoperability Regulations 2011. Regulation 6 states, in order for the application to be valid, the application must be made in writing to the Safety Authority and accompanied by a certificate of verification in relation to notified national technical rules. How standards are changing. In this section, we will cover the direction of travel for national technical rules, the direction of travel for national safety rules, and the direction of travel for national operations publications. In recent years, there has been an increase in European and UK requirements that have been published, e.g. there's now 6 CSMs and 11 TSIs. Where there is a common European or UK requirement, we can't retain the equivalent railway group standard requirement. It is redundant as a national rule. But it is recognised that a redundant national rule may still remain valid. RSSB has reviewed each national rule. They have then tabled a paper at the relevant standards committee containing a cogent argument on what to do next with the document. 4 options were considered. They are: number 1, reclassify the content into a RIS. Number 2, reclassify the content into a guidance note, where they continue to add some value. Number 3, withdraw them completely where they duplicate a European or UK existing requirement. Or number 4, leave them as they are where there is still an open point or specific case to fill. All national rules will be reviewed by January 2017, in line with the revised Railway Safety Directive. Also in January 2017, responsibility for authorising changes to national rules will move to European Union Agency for Railways. At this time, we don't know how this will affect UK standards. One particular type of national safety rule is changing in a different way. They are the rulebooks and working manuals. The OPU-TSI has removed responsibility for drafting these documents from the Member States. Therefore, these documents can no longer be classified as national safety rules. They are now known as National Operations Publications. The OPU-TSI still requires RUs and IMs to have these rules and does not stop them from using common industry rules that have been developed collaboratively and managed through standards committees and published by RSSB. An overview of the 7 standard strategy modules. In this section we will cover why we have a wider strategy for standards, the 4 RSSB strategies, 7 standard strategy modules, and where to find out more. In January 2015, in response to law surrounding standards changing, the RSSB Board commissioned the drafting of the wider industry standards strategy. This was completed in late 2015 and approved by the Board on the recommendation of the Industry Standards Coordination Committee. So why might a wider industry strategy be useful? Well, It will consider all standards used by industry, not just those managed by RSSB. It will ensure greater transparency about the work industry and RSSB undertakes to maintain and develop standards. It will provide RSSB with an opportunity to look at where it should focus its resources. It gives RSSB the opportunity to adapt RSSB managed standards to fit current regulations and to anticipate the full railway package published across Europe in 2016. And finally, it gives industry a common direction of travel for the future development of all railway standards. Additionally, the standard strategy also aligns with RSSB's other three key strategies. They are the Sustainable Development Principles, the Rail Technical Strategy, and leading health and safety on Britain's railways. There are 7 modules in the wider industry standards strategy. They are Module 1, Rail Group Standards as National Technical Rules, Module 2, Rail Group Standards as National Safety Rules, Module 3, National Operations Publications, Module 4, Rail Industry Standards and Guidance Notes, Module 5, Technical Specifications for Interoperability, Module 6, European and International Standards, and Module 7, Company and Project Standards. Module number 1, Key Points. Future rail group standards will only set out national technical rules to address specific cases, open points and technical compatibility with legacy assets. We'll work through all rail group standards and withdraw requirements which duplicate or conflict with TSIs. We will develop flexible approaches to standards change projects, and where possible we include guidance in rail group standards rather than in separate guidance notes. Module 2. We review all rail group standards identified as containing national safety rules using the Rule Management tool. This will identify rules that deal with matters already covered by the common European requirements. Reviewing these 50 rail group standards will take time, but we are aiming to complete the task before January 1st, 2017, when a revised Railway Safety Directive, coming in under the 4th Railway Package, will require national safety rules to have been cleaned up. Module 3. National Operations Publications. RSSB will reclassify all NOPs to recognise a new classification as rules required by the OPE-TSI. We will use existing processes for making and modifying these rules, but the content of NOPs will no longer be constrained by the scope and format of railway group standards. RSSB will communicate the reclassification industry, emphasising that RUs and IMs are required to have rules in accordance with the OPE-TSI, and that the NOPs currently provide these rules. There will be no new requirement or additional cost on industry. Module 4. Rail Industry Standards and Guidance Notes. There will be a systematic campaign to educate the community of standards users to increase their understanding of the benefits to them of RISs over railway group standards. RSSB will transfer requirements withdrawn from railway group standards to rail industry standards, provided the requirements are considered to be useful or necessary. We will establish a process for standard committees to provide observation and comment on deviations from the requirements of a RIS. We'll also establish an objective with a defined delivery date for RSSB to develop proposals for determining the appropriate content of guidance notes and the style in which they are drafted. Module 5. Technical Specifications for Interoperability. All TSIs have now been revised to extend their scope to cover the whole mainline railway system. They are now mature documents. Most of the work on the current generation TSIs was completed by late 2014. Future work would only be to close open points and to generally refine their requirements in the light of experience. The implementation plan for the OPE-TSI is potentially very significant for our rules. RSSB is currently facilitating a working group tasked with developing an implementation plan for the OPE-TSI. Module 6. European and International Standards. The proposed strategy for European and international standards is to continue broadly as now, although RSSB will review and if necessary adjust or refocus the support it provides for the development of European and international standards. We are aiming to increase industry's awareness of the work done to develop European and international standards, the support for that work provided by RSSB, and the value of such standards. RSSB have obtained an extension to its agreement with BSI to provide project management and sectoral services for the BSI National Railway Committees. Module 7. Company and Project Standards. We will encourage the development of a RIS where there is a common need for a standard, so reducing the need for company-specific standards. RSSB will provide small-scale advice on developing standards and identifying publicly available standards that might obviate the need for a company standard. We will generate a common set of discrete requirements for key publicly available standards, in particular TSIs, for inclusion in the requirements management tool being developed by RSSB. We will support the development of a documentary reference system as company standards to be used as codes of practice in the context of CSM-RA. And we will provide formalised and expanded guidance to projects about standards based on advice previously provided to HS2. You can find further videos and information on specific types of standards on the other pages in the standards section of the RSSB website.